This is Eric Niederlander with Trusted Elder Law and Asset Protection, a Pensacola, Florida-based elder law and estate planning law firm. And my name, again, is Eric Niederlander. I'm licensed to practice in the state of Florida and Alabama. I serve clients all across both states. Today, I want to talk about probate in the state of Florida. And the Florida probate, there's basically two forms of probate: a summary probate and the formal probate. The summary probate takes about 90 days from start to finish, whereas the formal probate takes 8 to 12 months to complete, typically, as long as they're both uncontested. We can do a summary probate when assets are less than $75,000 or the decedent's been deceased for more than 2 years. The formal probate is for assets that are over $75,000, or if the decedent's will requires a formal probate and doesn't allow a summary probate if the assets are less than 75. And another time that we have to do a formal probate is when the decedent owns real estate in other states. We have to open up probates in each one of those states where they own real estate, but we first have to open up the probate in Florida and get letters of administration. So that would be a formal probate, and then the personal representative would take those letters and open up probates in the other states where the decedent owns property. But when someone passes away and they have a homestead property, we can still do a summary probate if the rest of the assets are less than $75,000, because in the probate, the house has a zero value because it's exempt from creditors. So we could do a homestead and then $75,000 or less of unexempt property and still do a summary probate. In the summary probate, we basically say, Judge, these are the assets that need to be probated. They're less than $75,000, or the decedent's been deceased for more than 2 years, so we can do a summary probate. And these are the beneficiaries of these assets, either as described in the will or via the laws of intestate as prescribed by the state of Florida. And so after notice has been sent to the Florida Department of Revenue and the Health Administration, which is Medicaid, we can forward the order to the judge. And essentially when the judge signs it, you get an order saying that whatever the assets are should be released to the named beneficiaries. Also, the homestead, if there's a homestead, the order will act as a deed transferring the homestead property from the decedent to whoever the heirs are that are receiving the homestead property. So if someone in your life has passed away and you have assets, or they had assets that were solely in their name at the time of death, and you need to get access to them through a probate, give me a call. I can be reached locally in Pensacola at 850-607-2222, or toll free at 855-ELDER-FIRM. And I can be found on the web at trustedelderlaw.com. So give me a call. We'll see what we can do for you, and I look forward to hearing from you.